right. Sorry I'm a little late, y'all. Had to get everything set up. Good afternoon. Good evening. How everybody doing? Hopefully everybody had a good day. All right. Before we begin, on a scale of 1 to 10, how good can y'all hear me? I might have to move this camera some. On a scale of 1 to 10, how good can you hear me? All right. I'm gonna put the call-in number in the chat. What's good, free game? Okay, you said 4. All right, let me try to fix the sound right quick. Give me a second, y'all. Make sure I got my microphones good. All right. What about now? What about the sound now? I'll try to move my microphone around so hopefully y'all can hear me. On a scale of 1 to 10, how good can you hear me now? Let me put the call number in too. I'm gonna put the call in number in the chat. Y'all just press 1 to talk, then we can talk. See, I'm a little low. I wonder why is the volume low? I wonder. I might just take that microphone thing out. 6. Okay, I moved the microphone. I moved the microphone some, so I'm trying to see. I'm probably gonna have to pick it up or just get a little close up to it to talk to everybody. Y'all hit that like button for me if y'all don't mind. Hit that like button for me. The call in number is in the chat. Press 1. We can talk. Levant, what's good, man? You been doing any studying? Gotta make sure y'all doing your studies, man. It's the only way you're gonna get this stuff. All right. I was looking at where's that case at? Right here. This might not be the case. Hold on, y'all. I'm looking at this case right quick. This is from 1948. And this is from 1986. I might read this one. Um, I think I'm gonna read this one. Let me go back and check the chat. Okay, everybody's saying I'm at a 5 or 6. I'm gonna take the microphone cord out, and we'll see if that works. Sorry about that, y'all. All right. I just took the microphone cord out now. Y'all tell me what's the volume like now. I just took the microphone cord out, so the audio might be coming from my laptop now, but I don't know how loud it is. Um, where are you located at? Mr. Logan? Where you located at? You can if you have time, Mr. Logan, you can call in the show. There's the call in number is that 319 number. You call in and you press one, and then we can talk. That way, if you have any questions or whatever, then we can just go ahead and get that on. Go ahead and get that started for you. I'll be here for like 2 hours maybe. Okay, good. I'm glad the volume is better. Appreciate that. All right, so I guess I'll leave that out. But anyway, as I was saying, um, West Central GA. Okay, so you're in GA. Let me. There may be a law library somewhere, but if you can't, all right, I tell you what. I'm gonna screen share, and I'm gonna show you where to go to find cases at. But you really just have to know how to do legal research. You have to know the keywords to type in. That's really it. Okay, you say you're multitasking. Okay, well you can call in if you have time later. That's fine. Just call in a little later. Y'all hit that like button for me. I appreciate it. All right. So let me. I'm gonna screen share right now, and I'm gonna show you the websites that I use to do legal research on and how to use them. I do that. I've done this plenty of times in my videos, but you may not have watched the video yet. So let me screen share. I should be screen sharing right now. All right. All right, I'm screen sharing right now. So let's go to, let me open up another window. Let's go to case text first. All right, case text. Let me show you how to use case text, Mr. Logan. All right, so you said you in West Central, or you close by West Central GA, whatever, it doesn't matter. All right, so this right here is called case text. All right, so you click up in here. This right here is a search engine. It works just like Google. So let's say you wanted to find cases on self-defense against public servants, you know. So you would type in something like right of self-defense against police, something like that. And then you would hit parallel search. Don't hit keyword search because keyword search works, but I don't like. I just prefer parallel search. Let me show you the distinctions between the two. So hit keyword search, and this is what's gonna pop up. Stuff like this. We hold that the defendant did have a limited right of self-defense against a police officer, that he was entitled to an instruction on that limited right. Blah blah blah. All right. So, but if you go up here and you hit parallel search, it just defines it more. So the right of self-defense against a police officer is qualified because police officers have a duty to make arrest and a right to use reasonable force when necessary. So let's say you're in Georgia, so you want to be very specific with what you find. So you would go up here, click. Let me go back to it so you can see it. See where it says all state and fed? You would click this arrow that's pointing down. You would scroll down until you find Georgia, which is right here. You would click Georgia, and you would click apply jurisdiction after you selected the so-called state in which you wanted to find the case law in. And it's going to pull up all the cases in Georgia that are relevant to that. In Georgia, the law of self-defense is the same for a police officer as it is for any citizen. So what this is basically telling y'all is everybody has a right to self-defense against anybody. Nobody cannot do anything to you without a lawful purpose and expect you not to defend yourself. That just don't even make any sense. Let me see if I can find something else. We're gonna say right to slay police officer in self-defense. That's how this stuff works. This is a search engine. So you would hit parallel search, and then we'll see what pops up. This is in Georgia. All of stuff in blue, this is what you read. In applying the law of self-defense, a defendant is justified to kill another person in self-defense. I'm sorry, in defense of self or whatever. This is a principle. This does not just apply in Georgia. So like if I wanted to just be general with this, meaning all over the country, just to see if this is really a principle, then I would not select any state or any federal court either. I would just hit apply jurisdictions, and then you're going to see it all over the country. It's going to be all over the country. Ex parte Edwards, 1983, Alabama. The citizen may resist an attempt to arrest him, which is simply illegal to a limited extent, not involving any serious injury to the officer. He is not authorized to slay the officer except in self-defense. That is, when the force used against him is felonious, as distinguishable from forcible. So nobody can do anything to you without a lawful purpose, and reasonably expect you not to do anything to them. It doesn't make any sense. This is just in Alabama. It's all over the country. He is not on. Let me see. Okay, it looks like they cited the Alabama. Yeah, it says we approve the language used in Adams versus State, Alabama. Reading: the citizen may resist an attempt to arrest him, which is simply illegal to a limited extent, not involving any serious injury to the officer. He is not authorized to slay the officer except in self-defense. That is, when the force used against him is felonious, as distinguishable from forcible. So on and so forth. It just goes on and on and on. This is in Alabama. This is Nevada. This is federal court in Illinois. The use of such force by police officers invokes the right of self-defense. So let's see what this is. What's this? In Benderfield, if Benderfield was arrested, the time of the arrest is crucial because in Illinois, an individual does not have the right to use force to resist an arrest, even if the arrest is unlawful. There is a limited exception. However, when the officers use excessive force to effectuate arrest, the use of such force by the police officer invokes the right of self-defense. So what they're saying is, once the officers start using any type of force that is beyond the scope of necessity, then you have a right to defend yourself against that force because they're applying more force than what is necessary. Does that make sense? I mean, that's all this stuff is saying. Let's go back to the chat and let's see. Says he can't hear me. Y'all hit that like button. Hit that like button for me if y'all don't mind. I'm multitasking. Maybe Gordon College, but I can't drive right now. I can't hear. If you are watching with your phone, use earbuds. I don't know, y'all. I don't know what the. Let me go and check the volume on here. Let me go back to the settings on here. Okay. I don't know. All right, I'm gonna turn one of the microphones off, and y'all tell me what you hear. Let's go and see what this is. That's the aux. What is this? All right, I turned that one back on. All right, mic, aux. I'm not really sure which one of these is working. Desktop audio, mic. I think I might have to turn one of them off. I'm not really sure. Let me check the volume and see. How does that sound? Is that good now? Hopefully that's good now. So maybe Gordon College, but I can't drive right now. I can't hear you. If you're watching, put your earbuds in. Volume is good. Okay, everybody's saying volume is good right now. Okay, if the volume is good right now, I'm gonna just leave it where it is right now. But if it gets bad, y'all just let me know. Um, Back to you, Mr. Logan. So what you do is this is what you do. You go on case text. Go to I'm put let me put the link to the case text in here for you. Oops. All right. I'm gonna post a link into the chat section. I tell you what, let's just do it like this. I'm gonna post the actual link that I have in here. All right, there's a link to case text right there. You click that link and you do what I told you to do, and you should be good. It's a search engine. It works like a search engine. Y'all hit that like button for me. The another website that I use is called um, case.law. This is one of my favorites that I like to use because they have extremely old cases on here. So let me show you what I'm talking about. So you're in Georgia. So Georgia is right here. All right, so Georgia, they go all the way back to, they start at about 1805. Yeah, it looks like they started about 1805, about right here, 1805. Let's see. Yeah, so if you click that, so right now they only have one volume. But if you click on that volume, these are all the cases within that volume. And they start at 1805. These are the cases that you need to read, ladies and gentlemen. Y'all need to read these old cases. Always read the old, man, they gonna just flat out tell you in the old cases. They don't care. They're just gonna tell you what it is. This is where they're getting all their stuff from, man. These so-called judges up today, the only thing that everybody is doing is everybody is just, it's all hearsay, y'all. Everybody is just repeating the arguments and clearly established case law of the preceding judges, so-called judges before them, and arguments. That's all we're doing, and we're making reasonable conclusions based on these old arguments. That's all we're doing. That's why you got to read these cases. So that's just one report. But like if you go to like a current one, this one starts at 1808 and it goes all the way to 2018. So this is the Georgia Supreme Court. So you would click on that. It's going to show you all these volumes. You see this? This is 302 volumes. But just you click on volume one, there's probably over 200 cases in here. These are all cases. All right, so let me show you how case.law works. So it works the same exact way as the case text. So let's type in let's say you want to know what type of government that you have. You want to say Republican. Let me see. We'll say Republican form of government. Probably spelled that wrong. Yeah, I did. Republican form of government. So we're going to type in guarantee. Guarantee a Republican form of government. This is the search engine right here. That's why I'm typing it up here. So we're going to type that in. We're going to press enter. Now you want to, let's say you want to go and find the old cases, because that's what you need to do, because they just tell you how it is. So what I do is I go from the time period right here. See where it says date from, date to. So I started about 1700, and then I go maybe to about 1900. And if you want to get, more technical with it, or in other words, specific with it, if you wanted to just find stuff from Georgia, you would just go down here and you would just click on that, and then you would hit enter. And it's going to pull up everything with that in it in Georgia. This is 1869, 1869, 1852, 1863, 1848, yada, yada, yada. But the words up here that you type in, they're going to be bold over here on your right. So what is this? Shorter versus Cobb, 1869. Let's looks like it's the same. No, it's not the same. Is it? No, okay. They're probably these cases are probably citing one another or something like that, because they was both decided in the same year and they're in the same volume. So but let's go to we're gonna go to this one. We're gonna click on it. All right. It tells you everything you need to know about the case. This case has 43,000 characters in it, and it's about 7,000 words. So on a scale of 1 to 10, I'm going to say this is probably about maybe 12 pages. Shouldn't be over 12 pages. So what I do is I like to download the cases in PDF files. So you see this right here where it says PDF. You click that. Once you click it, the PDF file of this case is going to pop up. So in other words, somebody has already scanned, oh, well, it's 21 pages. In other words, somebody has scanned this book. Somebody in some library somewhere, they scanned this book, and they got all the pages from this case out of this that law book. And let's see, you just read the case. These are gonna be old cases, so you're gonna see stuff in here that's just it'll just shock you. Like it would really just shock you. I think this is the case. Let me go back check the chat. I take notes. Still haven't finished last week's video. Okay, cool. All right, let me go. Okay, we got a call online. All right, caller 8588. How you doing?
Yeah, all right. This is Gary. I've been trying to send you some information, but your mail says delivery fail.
Did you? Well, I was gonna ask you, did you send it to the right email? But I'm assuming you did. Y'all hit that like button if y'all don't mind. Yeah, you can print those, by the way, Mr. Logan. But I'm sorry. Go ahead, Gary.
Yeah, I'm getting a rebounds back to what I'm saying on your line.
Do you have the I guess the
I'm
live
hearing
video?
double.
Okay, is the live
Yeah,
is it muted?
yeah. I only get you from my headset.
And you
I
still
don't get I'm not even hearing you right.
okay? So you have your headset on and you still hearing double? You still having issues with the hearing?
Yeah, but it's okay. I'm ignoring it. I'm just letting you know what I'm getting.
Oh, okay, okay.
It's very faint. What I was trying to send you was the Gerald Ford statement on 1974, the Amtrak bill, when he said Congress told them to go back into chambers and redo child support because they actually made it as a collection agency. That's it. Yeah, and the executive branch made it, not Congress, because the executive branch only did it for the departments and their units. So when you go to child support, you're supposed to surrender your rights. And that's how they get you, because you're surrendering your rights because it's a program. It's not law. People are not understanding it. It's just not law. It's a program.
I think there's some sort of equity at play here. When
Yes, they're doing it under the Interstate Family Support Act, which is the money part.
see where all of this stuff is, this is in a let me try to explain this to people. What Gary is saying is uh this is under a act, okay? It's under some form of legislation. Okay, statutes are not laws. Ordinances are not laws. Statutes only apply within their territorial jurisdiction. All right. So what's happening is when people created these a long time ago, when these people who actually owned the land here, I guess after they stole it from the Native Americans or whatever, through some sort of title by conquest, um, the people who allegedly owned the land then, they applied for a corporate charter from the legislature to incorporate a city, a political subdivision, in other words, a territory. All right. When they did that, the legislature said, okay, we'll do that, but you have to own the land, and then you have to designate where the boundaries will start within this territory and where they will stop within this territory. And then once they did that, and then they all signed up, they agreed to it through some sort of contract. In other words, they voluntarily made themselves subject to the territorial jurisdiction of the legislature. And when they did that, the legislature gave them a charter and said, okay, over this territory, this is the democracy that we're talking about. All right, because they had a right to do that because allegedly they owned the land at the time and so on and so forth. So they had a right to do that. But anyway, the legislature said the legislature says you can have a legislator. They call their legislator in that local government a city council. They said you can have a judiciary. They call that judiciary a municipal court or a city court or a mayor's court. And then they said you can have an executive branch of government, which is the mayor. You see? Do y'all see what I'm saying? That's what they did. But all of this stuff is it's in a territorial jurisdiction. And what people don't understand is this: these territories where they have these so-called courts at. Let me see. Somebody's saying I'm low. Says you're low and your guests are usually way louder, causing one to constantly turn the volume up and down. This channel, their way be equal. I got all right. Let me let me try to fix that, y'all. I don't know what it is, but let me try to fix it. Let's see. Mike Ox. All right, I'm gonna hook the other microphone up. Give me a second, y'all. Got that. Okay. So let me turn that one off, and let me keep this one. Which one is it? I don't know which one it is. All right, all right. So we gonna try this again, y'all. Kind of lost my train of thought. All right. So how is the volume now, y'all? Because I'm getting like some people are telling me it's good, some people are telling me it's bad. I don't know.
I hear you perfect. My headset.
Okay, is the echo still there? Is the reverb still there?
Yeah.
I don't know what it is, then, man.
It could be just my headset.
Yeah, that's possible. That's possible. Screen. I don't know. We'll see. Oh, he says that's better. Okay, so let me switch it back to what it was then. All right, so everybody's saying that's better, so I'm gonna switch it back to what it was. Um, all right, so hold on. Which one was it? Was it this one? Yeah, it was. No, it was the other one. Okay. All right, so we'll leave it like it is. Hopefully everybody says good. Okay, he said I'm fine. It's him loud. Maybe not you. I don't know. All right. So let me I'm gonna backtrack a little bit where I left off. Okay, so when they created these territories and the legislature authorized them, hey, you can have a court, you can have a legislator, you can have uh, an executive, you can have a police force, you can lay and collect taxes, so on and so forth. What they did was they created another state. It's like a miniature state, though. It's like it, but it's within a territory. It's a territory. So, what happens is, in other words, that so-called miniature state is really an administrative agency. So, in other words, the city and the county is an administrative agency. All right. So, but what they're not telling y'all is this: the legislature, even though they authorized this territory to have a court and a judge, the legislature does not have any judicial authority to do that. They don't have judicial authority to give to a judge, in the sense that it's judicial authority that can be that the people can be subject to, if that makes sense. In other words, that private rights could be subject to, if that makes sense. And they also, what was it? The legislature there, the legislature, which will be the city council, they don't have the legislative authority to designate, in my opinion, or in other words, to authorize or to deposit quasi-legislative authority into the city council. But that's what they're doing. That's what they're doing. So when they do this and they start enacting statutes, everything within this territory is going to be under a statute, and it is going to mimic all four of the jurisdictions that were conferred on courts of general jurisdiction, meaning superior courts, meaning courts created by the Constitution. It's going to mimic all of those jurisdictions. For example, common law. They might authorize the so-called judges within these territories to adjudicate actions via statute that mimic common law actions, or equity actions, or admiralty actions, or maritime actions. That's what they're doing. Everything over there is like, it's a form of law, but it's not really law. What is it? It's the appearance of law. It's just the color of law. I know this is probably confusing some of y'all, but that's exactly what it is. That's what it is. So what people don't understand is this, man. Even if the legislature did not create any courts or any political subdivisions, the system would still be complete. It's complete because the people created courts in their constitution called superior courts, or courts of general jurisdiction. Courts of general jurisdiction hear cases at law, in equity, in maritime, and admiralty. That's what they do. They act with statutes or without statutes. These are the courts that the legislature does not have any control over. I did a video on this called, I think it was general jurisdiction versus limited jurisdiction. I did a video on this. I talked about this a lot, but that's basically what me and Gary are trying to get you, at least what I'm trying to get y'all to understand, is all of this. It's not law. All right, all of this, to be honest with you, it really is voluntary. I'm not even gonna lie to you. All of this stuff is voluntary. Just like when the people applied for that charter that was offered to them by the legislature, they did not have to accept that. Because to be honest with you, you can actually, based on the cases that I've read, you can actually establish your own de facto governments. It can be a private de facto government. You let me see, 100 people can buy them some land, move out in the wilderness, whatever they want, build up this land, establish their own courts, just so long as they agree to it, and they adhere to the judgments enforced by those so-called courts. That's valid.
Then you're going to get another Waco, and the government's going to move in.
Yeah, well, I'm telling you, like the cases that I read, they clearly say that that's valid. Because if you're not protesting it, you're not objecting to it, you're acquiescence to it. You see what I'm saying? So equity is not going to allow you to invalidate that judgment. It's valid. The government, look, man, you and the government, to be honest with you, you have more rights than the government. Just like Yusuf said, but just so long as you remain where you're supposed to be, which is outside of their corporate territorial jurisdiction. You got to get out of there. You see, under the protected right of the people to contract. Yeah, you have man, look. if I was to show y'all these old cases that I read about contracts, parents, like it doesn't like it applies everywhere. This is what people don't understand. The government is really, they, to be honest with you, they really kind of irrelevant for real, because you don't need them to do business. Anything can be used as money. Everybody has unlimited credit to the extent that somebody is willing to accept your unlimited credit. Your word is your character, your face card around the community in which you live in. That's credit. Your reputation is credit. How do you do business? That's credit. What do people think about you in the community?
That,
Do you have any co-signers? Do you have anybody to vouch for you that you pay your debts, that you're a law abiding, citizen, or a sovereign, or whatever you want to call it? Y'all hit that like button for me. I'm sorry. Go ahead, Gary. Let me go. I'm going to get me some water right quick. I'll be right back.
so within the program, fathers don't have any rights within the program, but you have to stand up and force them to see your rights. The IRS says all income, okay, is supposed to be accountable to the IRS.
Okay.
But within that program of child support, the mother doesn't have to claim that on the IRS, according to the government. But the IRS says she does. But the IRS also gets money to enforce what they call that uh, income with order
Income due
liens
in order or
against
something
you
like
from
that.
the IRS. Yeah, when they hold your income tax, okay,
Okay. Okay.
they get money for that to do that. But the IRS says all money she's supposed to claim. That means your money that you're giving her in child support, she's supposed to claim it. But within that program, you have to see that she doesn't have to. So within that program, everything within that program, she's exempt. But the father has to pay all this money to the child support agency. And you can't deduct it from your wages as a loss. So what they did was they created an exemption for the mother, and the father has to pay everything.
That's the whole
He
purpose of
can't
this.
claim no deductions.
That's the whole purpose of that Treaties of Rose book. That Treaties of Rose book is on point. He like that. Those cases go all the way back to like the early 1800s. They might go back further than that. They on point. But see, here's the thing though. I mentioned this. And I'm gonna say it again because some people are probably new. Like we were just talking about within these territories, these are territorial so-called courts, even though they're not courts. All right. So what what the actual judiciary does is when they create or when they fashion a rule or a case law, so to speak, the legislature will bring that law over it into their territorial jurisdiction for their agencies to adjudicate. But what they do is they take out stuff that they don't want. They modify it because it's over a territory. They have essentially they have plenary power, generally speaking, within these territories. Generally speaking, so they read these case laws and they say, well, we like this, this, and this, but we can't use this because it's not in the benefit of us. So we're gonna take this out, and we just not even gonna tell them about that. Like something. Let me see if I can find that case I was just reading. Um, I'm sorry to cut you off too, Gary.
No, go ahead. You
Um,
know me, I'm going to interrupt you.
all right, let me I'm gonna read y'all something, right? It's about, what is it? Looks like it's about 5 pages. In this case, it's from like 1819. I'm trying. Let me see. Where is it? Where was this at? I don't know which. I don't know which so-called. It says Eastern Circuit. Anyway, it's over here. It was in this country, but I want to read something to y'all. um, I'm gonna screen share it with y'all so y'all can see it too. If you have any questions, just press one, and I'll get to you as soon as I can. But let me read this case right here first. Let me screen share it. I'm gonna show y'all what I'm talking about. Where screen share? Right, right here. These y'all gotta go and read these old cases. So this is Samuel B. Angel versus Arthur McLeland, McLellan or whatever. When a minor leaves his father's house voluntarily for the purpose of seeking his fortune in the world or to avoid domestic discipline and restraint, the father is under no obligation to pay for his support. Does that let me show y'all something. How this ties into what this
Yeah,
is talking.
that's
Go ahead.
so within that program. So within that program, they say the father is supposed to pay for his college. How the hell can that happen?
It's what they when they do that,
If the mother goes to court and says, when the mother goes to court and says, I want him to pay for his college, okay, the judge is actually supposed to make it where he's paying under agreement. He agreed upon it, but they don't. They force it on the father.
I know exactly what you're
The
talking
father is,
about. That's what I'm trying to get people to understand. They're modified all of these principles that were established over in the real courts, in the courts of general jurisdiction that were created by the Constitution. They take those case laws and they bring them over into their administrative territorial courts, so-called courts, by writing legislation and authorizing them to do certain things and not authorizing them to do certain things. Because over there in the territories, they can only do, generally speaking, what the statute allows them to do. That's what I'm talking. They're modifying this stuff. They're changing it. They're amending it. They're taking out what they don't want and leaving everything in that they do want. That's what they're doing. But I get exactly what you're saying, Gary. Like
and
how can you do that? That's what they do. This is what I'm trying to get y'all to understand. That's what they're doing. They've been doing that for a long time. They're confusing people by calling it a court. It's not a court. If they wanted to, they could easily change the name to the Child Support Administrative Agency or whatever, and they can take it from a court of general jurisdiction and actually create an administrative agency and have them adjudicate this stuff. But they don't want to do that because it'll be too obvious as to what they're doing. But that is what they're doing.
but then they would need a contract because that's what contract law is about. They would have to go to small claims then. You see that nobody goes to small claims. They kick it to family court because it's a family court order. You never see anybody in small claims.
Not a lot of people. No, not really. Not that I know of anyway. I don't even think they cases
Yeah.
be on. I haven't even read cases like small claims court cases online. I don't even know if they put them online.
That's what one thing we have to do is start putting our cases online so it's available for other people to hear. One of the biggest things I'm fighting for is passports. Judge, I can't find no case law that says judges have the authority to tell you to sign a passport.
Don't no, they can't. They can't force you to do anything because that's not a valid contract. If you're forcing me to do it, that's not a valid
It's
contract.
outside. The United States passports are governed by the United States Foreign Bureau of Affairs. Okay,
That's an administrative agency.
it's the United States government.
That's an administrative agency.
But these governments, right? But they're also within that program. Because if you read, they'll say, "Oh, you go to family court and have a judge sign that you can take the kids outside." But the passports there's 3 steps that only a judge could do. If he needs a medical assistant, if he's going to college overseas, something like an emergency. It has to be something in an emergency. A mother going to visit her mother over there to allow the kids to see is not an emergency.
No, that's no.
But what they do is they'll take your rights away for saying, well, he's not communicating with the mother. He can't communicate. What they did with me. And, they'll say, oh, Mr. Williamowski is defiant. He believes the law don't apply to him. Well, in that case, it don't, because they say two-party consent. It's plain language.
You have
two-party consent.
You have every much right to object to your kid leaving the country, as the mother has to say that her kid can leave the country. So how do you balance that out? You would have to do something. That'll be some sort of equity or something like that. That's just my
how
opinion.
the mother gets away with it. How the mother gets away with it is by going to court and saying, "I don't want the if you're behind on arrears." How they get away with it is if you're behind on arrears, they take the father's passport away, and if you want your passport away, you have to pay to what they call a purge. They call within that family court, it's called a purge, but it's actually a bond. They want you to pay the bond, like a $50,000 bond, so you will come back. And if you don't come back, the mother gets that money that you paid into. So the father they won't do, because it's written that the mother is able to do it, and the father they won't do, because they don't want to restrict the mother.
Let me tell you something. That's a great idea. You can copy that idea and use that against your mother. I mean, your kid's mother. You can require her to have a bond before she leaves the country with your kid.
And that's where it's written.
No, what I'm saying.
That's how it's written.
What I'm saying is this: it doesn't matter if a statute is authorizing that or not. You still can do that. Everybody can do that. And I'm not joking.
But they won't enforce it.
Huh?
They won't enforce it.
To be honest with you, I kind of disagree with that. I would have to see that for myself.
Well,
I would have to see that for myself. And I'm not saying you're wrong, because generally speaking, these people, they think they can do whatever the hell they want to do. That's how they think. But I would have to witness that for myself. But you can require her to have a bond. Anybody can do that.
In my letter to the child alert passport people, I stated that in there. I said you could request a bond, and besides that, the mother, you're supposed to protect the child from injury. So there's no court, there's no hearing. They don't have a hearing on this. The passport people don't hold court. They could just say yes or no, and to this date, the mother has not gotten her passport for the children.
When you look, man, look. This is what's going on, man. Like, I don't know how many times I gotta telling this to people. These are agencies, and they are adjudicating what the legislature authorizes them to adjudicate. None of this stuff is going to be in your favor over there. But I'm telling you, you can require her to have a bond before leaving this country with your kid. And you can enforce that in a court of equity.
And how they did away with that, they said, oh, she has a constitutional right to travel with the kids because she has custody,
she signed away, that's
custody,
right,
which is considered.
She signed it. She she has hindered or she has weakened that right, so to speak. When you do it in the country, because that's how you
Right.
waive rights. Generally speaking, you waive rights in contracts, expressed or implied. They prefer it to be expressed, meaning written. Sometimes they'll say, you can implicitly do it too, but yeah, anybody can waive rights. Look, man, y'all got to understand. You don't need the government. You can move out into the woods, and let's say you started studying all of these statutes, right? And you say, I like this. I'm gonna incorporate that over here in my, onto my property in my own private jurisdiction. I'm gonna incorporate that over here, and I'm gonna adopt that. That'll be the law over here. That's what you do. You don't need these people for You don't need these people for nothing outside of what they were originally created for. You do not need man. These people are irrelevant. You don't need these people, man. You don't need them. But I think your problem is, Gary. And don't take any offense to this, but you have to study more to know what your rights are and to properly enforce them, and then you can determine.
Oh, I know.
Go ahead. I'm sorry.
I know all that. I know all. Enforce them, but they'll just turn around and walk over you because you don't have an attorney and you ain't got money to
That's
go
one thing
take
you're
it up
right about
into.
that. You're absolutely right about that. But you have to cost them money. When they start doing that, you start filing lawsuits. Start costing them. I'm telling you, they're gonna leave you alone when you start costing them money. I'm telling you what I know. Because it's not gonna be worth it anymore. It's like the cost of them bothering you is more expensive. They're not gonna bother you. You have to make an example out of them, like they make examples out of you, because they really do think that they can do whatever they want to do. They really think that.
One of the biggest things they love to do, and this is people got to understand, she doesn't have a right to attorney fees. It's if the judge wants it to do that, because if you pull up and you ask, is there a right to attorney fees? It'll come up and say no. People usually pay for their own, but the lawyer will put it in the contract in their divorce saying that you agree to pay her attorney fees. You gotta watch those words, what they use. You agree. When they put agree in it and you haven't agreed, you gotta attack that right away.
You gotta object to that. Where's your evidence? I'm already showing you that is a
Right.
lie. I didn't agree to it by objecting. So what other evidence do you have? She's saying that that's what I said, and I'm telling you that I didn't say that. So how are you going to make a reasonable conclusion as to who's telling the truth without any evidence besides her word versus mine? How are you going to do that?
And one of the things that they're supposed to do, is procedures. Well, if they say, well, Mr. Williamowski is not being reasonable, how are you going to determine that if you don't do a fitness test? But then they turn around and we don't need to do a fitness test. Well, the judge is making it based on a medical opinion.
This is
He
what
can't do
this is what
that.
people need to do, and I've kind of adopted this into my own litigation tactic when dealing with these people. When they so-called order you to do anything, especially when you know that they don't have any jurisdiction at all. In other words, their jurisdiction has not been properly invoked in a manner required by the statute, because these are not courts. These are so-called courts of not general jurisdiction, limited jurisdiction. So they can only exercise jurisdiction in the manner that the statute requires. And if they don't, then their jurisdiction is not properly invoked. So what you do is, when you're dealing with stuff like that, you do everything under duress. You have to put it in writing, though. Put it in writing. Like, for example, if you knew this court did not, this agency of this court, this agency masquerading as a court did not have jurisdiction, You would say, comes now John doing a special appearance under threat, coercion, and a divorce, to involuntarily submit to a forcible physical something like that. You know what I'm saying? You have to state the facts. You have to make the facts known on the record as to why you're saying that they don't have a lawful purpose. In other words, they don't have the jurisdiction to be forcing you to do anything. Like, for example, they say they want
I
you to
like to
take.
use the word.
Go ahead.
I like to use the word force compel order
Force compelled or
or commands
something like that. Yeah, I don't see
order.
anything wrong with that, but I would use the term like unlawful order, something like that. Unlawful. That's what I use stuff like that. Um, I mean I could draft something up like that, but it would probably take me 3 4 days or something like that, depending on the case or something like that. But that's how you have to get them, y'all. When you put stuff like that on the record, and if it's generally speaking, if it's not objected to, I'm of the opinion that they're gonna object to something like that. They're gonna try to dispute it, or that's if they can dispute it, something like that. But you want to get these people on the record caught red-handed, something like that. Like if they start telling you that you need to take a drug test or something like that, and you know that they don't have the jurisdiction because it's not properly invoked to order you to take a drug test, or if you know that you haven't voluntarily submitted to the jurisdiction of this administrative agency masquerading as a court, you can say I will issue like a special appearance under duress, or I'll waive the special appearance under duress for like $1 million fee or something like that. Just be ridiculous with it because that's valid. Y'all gonna think that y'all. Some people probably think I'm playing, but that's valid because all of this stuff is voluntary. They don't want to tell y'all this. It's all voluntary, all of it, because you have a
What
right
they
to
like to
enforce
do is
it.
put in the first statement of their order is both parties agree. That's what they love to do.
Yeah, they can do that all they want with me. I'm gonna object to it because there is nothing in the record that allows you to reasonably conclude to make that assumption. So you abuse your discretion when you did that. So of course I'm object to that. And also, everything in the court's record or whatever, it's only entitled to the presumption of truth. You have to rebut the presumption. They're just gonna assume that it's true because if you don't object to it or if you don't rebut it, they're just gonna presume that it's true, despite the fact that nothing in the record may not be true. That's why I don't, that's why I'm very careful with the cases that I read. I don't know if these folks telling the truth or not because these people will lie. I don't know if they're telling the truth or not.
One of the things, one of the things I'm going to be doing is buying that transcriber that you can bring to court, and
Uh-huh.
it's called Cloud. So you can put it on your thing. Say it's your transcriber, your thing to do transcripts because
Uh-huh.
they want you to buy their transcripts. Okay.
Uh-huh.
So what happens if they leave your statements half out or change words
They do that.
that
I'm telling you what I
you're
know. They
saying?
will do that.
So
They will.
I'll be
I've
writing
seen
a
it before. They will
I'll,
do
I'll
that.
be writing a I'll be writing my paper on allowing me to have my own transcriber in there, so I could transcribe because I'm going to bring sections in it when they say that the Constitution don't apply, but yet you turn around and say Constitution applies for her. How can it be? When you're saying one thing, the next thing you're saying against Mr. Williamowski, he has no constitutional rights.
Yeah, man, they wouldn't dare play with me like that. Man, I cost these people so much money, and I'm not like don't y'all don't take any offense to this. I'm not like other litigants. I don't care who you are. Like you don't threaten me. Don't put your hands on me. Don't do none of that unless you have a lawful purpose for doing that. If you don't have no lawful purpose for doing that, you either gonna get a lawsuit or you gonna get bullets. That's what you gonna get messing with me. because you don't have a lawful purpose for doing it. Don't leave me alone. Leave me alone, man. Man. Look, man, these folks, man, y'all. Whew, don't get me started, man. Cause boy, I'm not like other people, man. I'm peaceful. I don't like violence.
So,
I try to be peaceful all the time. You just leave me alone, unless you have a lawful purpose for
so,
interfering with my private life. Go ahead, Gary. I'm gonna give you like 5 more minutes, and I'm gonna start reading this case.
so what they're doing is in their program, they're using everything in their program, and all the attorneys that are around the defendant's attorney, the plaintiff's attorney, and all these agencies are just following the program. They're not outside of the program. It would not exist because the laws are stricter. You have to prove a lot, but within that program, everything is a presumption for them.
Yeah, you just gotta you pretty much just gotta anything that you read and you know that is patently false. That is a lie. You need to object to it or rebut it. Anything, or they gonna presume that it's true. That's what you need to do.
So how are we going to get you some information when I'm being blocked? Is there a better phone number?
When was the last time you tried to email it?
July 31st.
July 31st. Is the file
4 days. Yeah.
is it a large file?
Huh? No.
Well, you should be able to send it then. Try it again. You should be able to make sure you spell the email correctly. But you should be able to send it because I didn't
Yeah,
block
yeah, I
you.
got it.
I didn't block you from sending me emails. I didn't block nobody from sending me emails. So you should be able to still do it. Y'all hit that like button for me. Hit that like button for me, please.
I'll try it again. But your other email is not coming up. You got one Smart Lock TV, and then you have another one. That one got written right off.
I don't know. Let me. I'm gonna try it. I'm gonna put the email in the chat, and we'll try that out.
Yeah, but within that program, all it is a program, and you have to volunteer. And
It's all volunteer.
I had mentioned that the TANSTIP program is only for fathers that married people and single mothers who volunteer. That they say you have to go to work under the Personal Work Order Recreational Act, Reconciliation Act that was passed in 1988. I just put everything as human trafficking in when child support's human trafficking of babies. They don't like they wanted me to remove that. I said no. My yay is my yay and my nay is my nay. I'm keeping it in there.
Yeah. These man, you don't have like maybe 100 years ago, a little over 100 years ago. I think there was. I think the judiciary was. I think they were pretty good, and I think they were pretty fair. But today, you don't have that. These people are bought and paid for. I don't know who's controlling them. What they are very corrupt. I'm not joking, y'all. I see some stuff that you just you have to see to believe. You know what I'm saying? You have to read cases to believe to see what these people what they're doing. They don't care like when they
In child support,
huh?
in child support, it is the Treasury Department that they are following. They have to go by. The Treasury Department is the recoupment part of child support.
I don't know. I'm gonna let you. What you talking about the federal treasury, something like that, or the state?
Yeah, the federal treasury.
I don't know. I can't really say if you're lying or telling the truth. I don't know. Um,
Oh, you can look it up.
Huh?
You can look it up. See, what CRS? CRS, child support recovery, uh, child support recovery unit is also child support services in the Treasury Department. People are misunderstanding that when they say child support recovery service, it's actually Treasury Department. Because if they listed in there, you could say, what does the Treasury Department and child support have in common? And it'll pull up CRS.
It wouldn't surprise me, man. That is like it just wouldn't surprise me. Look, let me go ahead and read this case, man. Um,
All right.
I'll
Hey,
make it.
good talking to you. I'm turning you off.
All right. I think it's. I think it was that. All right. So let me get. All right. Look, when you call in, if you want to talk, press one. Let me go ahead and read this case. I'm gonna cross-reference something. I want to show y'all something. Let me read this again. When a minor leaves his father's house voluntarily, that means without the father's fault, for the purpose of seeking his fortune in the world, or to avoid domestic discipline and restraint, again, without the father's fault, without fault on the father is under no obligation to pay for his support. So let's go back here. Where are we at? Right here. The right to the custody and earnings of the minor children are reciprocal, and that whatever deprived the parent, we're going to say the father, of that right of the custody and services of the child without fault on his part, in other words, without fault on fault of the fault of the father, relieves the father from the duty to support the child. They've been new about this stuff, y'all. It's the same thing. It doesn't say it, but it's the same exact thing. This was in 1929. Right here, footnote 11, right here. And it does say that in that case, too. I have that case. 1929. This case that I just read, y'all, is from 1819. They've been new about this stuff, y'all. Been new about it, but they're hiding it. They don't want people to know it. You still have these rights. Even when they haul you over there into an administrative agency as masquerading as a court, you still have these rights, but you have to bring this stuff up, though. You have to bring it up and you have to argue it. Yeah, they probably gonna rule against you, but the higher you go up, I'm of the opinion that there's a chance that they should rule in your favor. That's my opinion. But I mean, I could be wrong because they corrupt, in the higher so-called courts too. But give me a second, y'all. I'll be right back. I'm gonna read this case and I'll be right back. All right, y'all. I'm back. Sorry about that. Let me check the lines right quick. All right. Let me see. I got a partial reimbursement from child support last year, and the check was from the Federal Reserve. That's interesting. I had a judge ask if I was voluntarily appearing after he read some rebuttals I filed in the case. Just because you're filing paperwork, that doesn't mean you're making a general appearance. I did a case on that. There's a video on my channel, SG. I think it's called "Filing Paper Doesn't Grant Jurisdiction 100% Proof" or something like that. Go check that video out. I'm showing you the case too. Um, let's get to it. All right. This was an action of assumption for money paid for the sundry articles of clothing and for board furnished the defendant's minor son in the West Indies. The action was tried upon the general issue, October term 1818. Okay, so this is from 1818. Before, well, that's when it was tried. Before Thatcher. Let me make this a little bigger. It was an evidence that the defendant's son had been indicted in this court for a felony, that a warrant had been issued for his apprehension, and that he had absconded. I'm sorry, and that he had absconded to avoid the same. We had gone. Let me see. To avoid the same, had gone to the West Indies, and that upon his application to the plaintiff, to whom the defendant was known, the plaintiff made the advances for which the present action was brought. The judge instructed the jury that if they were satisfied that the articles furnished were necessaries to the son, necessaries are like food, clothing, shelter, water, stuff like that, furnished were necessaries to the son in the circumstances in which he was found by the plaintiff, and that the plaintiff was ignorant of the circumstances under which the son was absent from his father, and a fugitive from justice, they should find their verdict for the plaintiff. And a verdict being so returned, the defendant filed his exceptions to the said opinion of the judge, where, for the plaintiff, as a general proposition, it will not be denied that the father is bound to support his children during the period of their legal infancy. We contend that the proposition is not only generally but universally true. I want y'all to pay attention to the verbiage, that the stuff that they're talking about in here. It is very, very, very similar to the stuff that is in this ebook. Very similar. Because this is where they're getting this stuff from. They get it from the old cases, y'all. That's where they get it from. And they bring it over into their administrative agencies masquerading as courts, and they modify it. They change it. They take out what they don't want in it for their benefit and to your detriment. That's what they do. We contend that the proposition is not only generally but universally true if the parent is of sufficient ability. This principle, which is founded in the law of nature, has received the sanction from repeated judicial decisions, and the humanity of our municipal law is shown in extending its care to infants somewhat further than is required by the law of nature. So they're talking about statutes, they're talking about ordinances. If an infant have a fortune which comes, what is that word? I'm guessing it's some Latin word, but I can't really see it. Anyway, the law will not allow even the interest of this to be applied to the maintenance of the infant, even though it be specifically ordered by the benefactor to be so applied, provided the father is of sufficient ability to maintain his child. The principles here stated are distinctively recognized as law by Parsons C.J. in the cases of Whipples versus Dowles 2 and Dowles J versus Howard 3. This is how they cited cases back then. If the father neglect to fulfill his obligation, a third person who furnishes necessaries for the infant is deemed to have conferred an obligation on the delinquent parent for which the law arises and from which the law arises an implied promise on part of the parent to pay. The general doctrine of this case last referred to is clearly recognized in the cases of Simpson versus Robinson and Krantz versus Gill. Look how old these cases is, y'all. This is where they're getting this stuff from, man. These authorities afford an ample confirmation of the doctrine we support. It is for the defendant, then, to take this case out of the rule. Two exceptions are mentioned in the cases cited. One where the parent has supplied a fund for the support of an absent child, which is regularly applied to that use. Another where the necessary supplied were to an unreasonable amount. excuse me, y'all. The defendant's case falls within neither exception, so he doesn't qualify for any of these exceptions. But it is argued that the defendant ought not to be charged because the son was prolific was profligate and absconded and was a fugitive from justice. If this is a bar to the plaintiff's recovery, it is incumbent upon the defendant. It is incumbent on the defendant to prove it clearly and explicitly. So first you raise the claim and then you prove it. This was not done, so the defendant didn't prove his case. Excuse me, I'll be right back. There's something in my throat, and I don't know what it is. Sorry about that, y'all. Okay, let's see. This was not done. All that is in proof is that a warrant was issued to apprehend the son for a felony, and that the officer returned a non est inventus. I'm not sure what that is. Let me see what that is. Some Latin word. Non est inventus. So let's go to Google. Non est inventus. Right here. Okay, non est inventus is a Latin phrase that means he or she has not been found. Okay, so they didn't find him. He gone, he left, whatever. This does not prove that he absconded from his father's protection. I agree. He might have left the country before the warrant issued. Or, see how they're making reasonable conclusions based on the evidence, because that's what they're supposed to do. They can't make unreasonable conclusions, meaning conclusions unsupported by evidence, because that would be an abuse of discretion in these administrative agencies. He might have left the country before the warrant issued, or he might have left it with the knowledge and consent of his father. But admitting the fact, it is in no defense to the action, which is founded on the obligation of the parent to support his child, and this obligation is not destroyed by an offense committed by the child against the community. There is not a dictum in the books authorizing such a conclusion. The other point, that the son was a spendthrift, is too vague to admit of the precision of the legal reasoning. This is not the so-called judge talking right here. This is somebody that's making an argument for somebody else. Excuse me. The other point, that the son, if the articles supplied were to minister to his I can't even pronounce the word. It looks like it's a variation of the word prodigal. I'm gonna say prodigality. Can't even pronounce the word. Oh, I know the word, but I just can't pronounce it. But anyway, it would be an answer. But it was never supposed that because the son was a prodigal, the father was thereby exempted from the obligation of supporting him with necessaries. And if so, the case is clearly within that of Van versus Valkenburg and Watson. So this is where, when you see right here, this is where, if I'm not mistaken, the so-called judge is going to start talking at. Let me check the lines, see what we got. Let me see how many more pages I got. I got 3 pages. I'll take the call right quick. Let me go ahead and take this call. Caller 9026. How you doing?
Hey, what's up, man? This free game.
This who?
Free game. That's the
yeah, what's good?
What's up, man? So let me ask you this. I had a dispute with the landlord,
Okay.
right, in my apartment. She wouldn't fix the housing. So the fixer, it was like a leak in my roof. She had that shit messed up for like a year. So I told her. So they finally came and fixed it after mold had came. And what happened? She still have a hole in my damn ceiling. So I'm like, man, I'm gonna stop paying y'all, bro, because y'all breaching the contract, the lease. So they trying to evict me. I went to court. They ruled in their favor, of course, in the justice of the peace court, justice court. So I did an appeal, but they want me to pay the rent to get the appeal. How can I get over the appeal, paying the appeal bond, to get an appeal? Like, you see what I'm saying?
It sounds like you're saying they make, I guess, in order for you to perfect the appeal, they seem to make a condition that you pay the rent. Sounds like it was ordered there. Somebody ordered that.
It was a woman that wasn't even a judge. I put in my appeal that my due process was violated because she's not even a judge. She don't even have a law degree. like she's a justice. She's a justice of the peace judge or whatever they call them.
Okay, where let me see, I'm gonna see if I can research this right here.
Look up Jefferson County, Texas.
So we in Texas.
Justice Court.
Justice. I'm gonna type in justice of the peace. Type in appeal. You say this is in Texas?
Yeah.
Let's see something. In order to perfect the appeal, the defendants, together with 3 securities, executed and the justice of the peace approved an appeal bond which reads as follows. So, well, this is an old case. That's from 1909. But I'm trying to see if if a statute is authorizing the justice of the peace that sort of discretion in order for you
Yeah.
in order for you to perfect your appeal. Let's see, when a valid appeal bond is presented to a justice of the peace by a party desiring to appeal, which bond is satisfactory to the justice, and he gives assurance to the party presenting same. I need to study this statute because agency. It looks like a conveyed court. I don't care what they say. The trial court ordered.
Yeah, that's not a court.
The trial court also ordered appellants evicted from the property and set an appeal bond in the amount of $27,000 per month due on July the 1st of the year thereupon. What is the it looks like they citing a statute right here. This is a case from 2020. Let me try to read this case. It might be something similar to your case. Let's see if I can try to have this just skip through it. They're citing statutes here too. So if these are the statutes that I need, I'm gonna read them. So plaintiff Thomas set order whatever Julia and Jessica shall intend to appeal from the county court. Judgment of possession was received in March 2020 because appellant did not timely file their notice of appeal. We dismissed their case without jurisdiction, blah, blah, blah. Philly First Bank filed a forcible detainer action against appellants asserting a superior right to possession in Harvard Frisco. On March 16, 2020, the trial court signed a judgment of possession finding appellant guilty of forcible detainer and ordering the First Bank to have possession of the property. The trial court also ordered appellants evicted from the property and set an appeal bond in the amount of $27,000 $2,750 per month due on the first day of the month. What does it mean per month? What are they talking about? Per month. That's the appeal bond. Let's see what they talking about. They got a statute in here. The writ of possession or execution or both, which shall be issued by the clerk of the county court according to the judgment rendered, and the same will be executed by the sheriff or constable. And in other cases, the judgment in which the county court may be stayed unless within 10 days from the judgment of appellant files a superseded bond in an amount set by the county court pursuant to section 24. Do you have a copy of the paperwork?
Is at home. Is at home.
I'm gonna need.
I'm not at home right
Yeah,
now.
I would need to see it. I need to find the statute to see because I'm not even sure if they can. I would be. I can't say it. I can't say that they can do it or they can't. I don't know. I would need to see. But now, let me see something. Justice of the peace. I ain't never really heard of nothing like that.
hmm
Justice of the peace.
So so what I'm thinking about doing tomorrow, I'm gonna go down there. I'm gonna go down to the county's office, the recording office.
Uh-huh.
I'm gonna look for the. I'm gonna go get the deed from their office. If that deed is not perfected, I'm gonna perfect that deed. And I'm gonna put it into a trust, and I'm gonna go to the federal court and do a bill in equity.
Well, that I don't know because you may be a stop from doing that if the facts are similar, the parties are similar, and you're in privity or you are actual party that litigated the case. What else?
Mm-hmm.
Um, but all of that's based on if the judgment in the state court was valid, the so-called court, and if it was valid. If it's not valid, then I don't see why you couldn't do it.
Yeah, because what's happening is they have a landlord agent, and the agent is not acting in persona because the agent have nothing to do with the contract.
Okay.
So so they're already in violation right there because they're having a third party to come to the court, and they're not acting. They're acting as a trustee, but like an agent, which is like a trustee to the contract. So either I can get the deed, or I can get the actual lease and put that into a trust in file in federal court.
I don't know. I don't know, man. I can't say you can't. I would try it. You know what I mean?
Yeah.
I would try it. Um, but like right now, I mean, to be honest with you, I'm kind of like at a standstill because I don't have the statute. I haven't read any of the paperwork. Um, I don't know if what the justice of the peace is authorized to do and not authorized to do. But I mean, I did see something in here in a case from 2022 that it seems like that the so-called court was allowed to charge $2,750 per month as a condition for the appeal bond, um, um, due to somebody being evicted from some property or something like that. But like I said, I would need to read your stuff, man, to give you an accurate answer. Right now, I'm freestyling it without knowing all of the facts and without the case law and the
Mhm.
statutes.
Well, what I probably can do to keep them at a standstill, but I don't know if it will stop them from doing a writ of possession because they're the appellate courts. But the federal court is not a part of that, which can stop the sheriff from doing it in a writ of possession.
Um,
So
they probably I mean, if they can stop state courts from doing stuff to you, I don't see why they wouldn't when they I don't see why they wouldn't be able to stop um another executive officer from doing anything to you. I don't, that's my take on it. I could be wrong, but I mean, that's my take on it. I think they can.
Yeah. So what I might do, and when you say court of general jurisdiction, that is that the civil court, or are you talking about federal court?
Federal courts are they not courts either, man. They limited jurisdiction. They look like courts, they function like court, but they ain't court, and they don't have no judicial authority. They not Article 3 courts.
Mm.
When I say courts of general jurisdiction, you're in Texas, so let's look at your constitution. Let's look at the Texas Constitution. In your constitution, it's going to tell you which are the courts of general jurisdiction. All right, this is 273 pages. When I find it, I'm gonna tell it to you. We got Bill of Rights, powers of government, legislative, judicial. All right, looks like it's on page 91. What is this? No, we're getting close. Judicial department. All right. So let's see. Judicial power vested in courts. Legislative power regarding courts. The judicial power of this state shall be vested in one Supreme Court, in one court of civil appeals, in courts of appeals, in district courts, in courts, in county courts, in commissioners' courts, in courts of justices of the peace, and in such other courts as may be provided by law. Oh, they throwing you all the way off with that. They so vague with this. This is crazy.
Yeah.
It looks like the Supreme Court, obviously that will be a court of general jurisdiction. In one court of criminal appeals, in courts of appeal. Oh, what are they talking? I would have to go on. Let me go on. I'm gonna have to go and read some case law on this. But they being very vague. I'm telling you right now. When I see this term bylaw, that means like a bylaw, a bylaw. When they say bylaw, they're talking about a statute. And that tells me right there
Yeah.
that this is an inferior, whatever they're talking about is an administrative agency. So it says the legislature may establish such courts as may deem necessary and prescribe the jurisdiction and organization thereof, and may conform the jurisdiction of the district court and other inferior courts thereto. This is from 1876. Let me see. We gotta go. Where we at? Let's get back to case text. Case text is gonna tell me where your courts of general jurisdiction at.
You got Telegram, Loke?
Yeah. I mean, I don't be on there like that, but I do have one.
Okay.
I gotta find. Well, we gotta go to Texas. They be trying to hide this stuff, man. They just threw me all the way off with that. I don't know what they talking about. They be trying to
Damn.
hide this stuff, man, and they hide it too good sometimes. Our trial courts are courts of general jurisdiction. Under the Texas Constitution provides that a trial court's jurisdiction consists of an exclusive, appellate, and original jurisdiction of all actions, proceedings, and remedies, except cases where exclusive, appellate, or original jurisdiction may be conferred by this Constitution or by other rules or other law on some other court, tribunal, or administrative body. Let me see. Holding that courts of general jurisdiction presumably have subject matter jurisdiction unless a contrary showing is made. Yeah, I already know that. Holding that a collateral attack on a judgment of a court of general jurisdiction in another court of equal jurisdiction is permissible if underlying judgment is void. This is see. I'm trying to find. A district court is a court of general jurisdiction. Okay. A Texas district court is a court of general jurisdiction. Okay, that's one. The district court is a court of general jurisdiction. Let's see what else we got. District court. The Supreme Court has pointed out that the district court in Texas is a court of general jurisdiction. Okay. So far, they just, let me see, Texas. So far, they just say district courts and the Supreme Court. Obviously, the Supreme Court.
While you was looking up, I asked Chat GPT. It was saying in Texas, the courts of general jurisdiction can adjudicate cases involving federal constitution issues such as those mentioned in Article 3, Section 2, Subdivision 1 of the U.S. Constitution are district courts.
Yeah, what people don't understand is the Constitution is law. It was created by the people. The people create law. So what they did was the people, generally speaking, all over the country, the people created courts for them to adjudicate their rights. They call these courts
Yeah.
courts of general jurisdiction or superior courts or circuit courts or district courts. That's what they call them. The legislature created agencies and they call these agencies courts. But these are not courts. They can't be equal to the people's courts because the people are sovereign and the legislature is not. So, and the legislature does not have judicial authority because that's clearly, they're clearly prohibited from having any judicial authority in pretty much every constitution. So if they don't have any judicial authority, then how are they going to create courts and invest these courts with
Yeah.
judicial authority? They can't do that. It's quasi. That's what they call it, quasi judicial authority. They're mimicking a court. It's not a court though. But they adjudicate public rights. They adjudicate the government's rights. That's why everything over there is drafted using statutes in the benefit of the government. That's what's going on.
Yeah. So it's the district court, not the federal court.
That would be correct. None of the federal
Yeah.
courts, none, and when I tell you none, I mean none of the federal courts, except the Supreme Court for United States of America, is a court of general jurisdiction. But once they start taking jurisdiction, in other words, once they start exercising jurisdiction under a statute, then they are no longer a court of general jurisdiction. They belong to the legislature. But that's what they're doing.
Okay.
That's what they're doing. Let me see. Are you
Okay.
watching the live right now? I'm gonna show you what I'm talking about. Or you can just go and watch. You can go and watch my video. General jurisdiction versus limited jurisdiction. Are you watching it
Yeah,
live right
because
now?
they got us. Hold on. Let me turn it on.
All right, I'm gonna show you what I'm talking about.
Go ahead.
All right. What's it? QUA. What is it? Quad hoc inferior. I might not be spelling this right. It's all over the country, man. Let me see. This is in 1931. All right. It's 1931. This is a principle. It applies. As a matter of fact, I'm gonna take just to show you it's a principle. I'm gonna take it off Texas so you can see it's gonna be popping up everywhere because it's a principle. Did I take Texas out? What is? Yeah, okay, here we go. Trying to find. Let me see. Let me read you the one in Texas. 1931. The rule is well settled in most jurisdictions and in this state that there is no presumption of jurisdiction where a court, although it is one of general jurisdiction, exercises special statutory powers in a special statutory manner or otherwise than according to the course of the common law. Since under such circumstances the court stands with reference to special power exercised on the same footing with courts of limited and inferior jurisdiction. They're saying once this court that was created by the sovereign people of each state, once this court of general jurisdictions starts exercising jurisdiction under a statute, I don't care if it's appellate jurisdiction, original jurisdiction, concurrent jurisdiction, I don't care what type of jurisdiction it is. Once that court that was created by the Constitution starts exercising jurisdiction under a statute, it is no longer a court of general jurisdiction. It's an administrative agency. It's a court of limited jurisdiction, aka an inferior court. That's what it is. That's why I keep telling people there's two Supreme Courts, and there are two Supreme Courts. Because you can invoke.
Wow.
Huh?
I say, wow.
Yeah. That's what's going on. I'm trying to see if I can find it. There it is right there. There, I was spelling it wrong. There it is right there. And it's all over the country. This is in Alabama, Texas. I've read this everywhere. I'm going to try to take it out. Let me see right here. I want people to see this stuff. I did a video on this a couple months ago, something like that. Here's another one. This is from 1922. You got one from 1945, 1947, 1960 in Iowa. Let's see. Let's see. All right, so let's go back up. I'm gonna read it to you in Alabama. This was a good. I actually posted this on my YouTube channel, on the community section of my YouTube channel. But I be trying to show. The reason why I do that, I be wanting people to see what they doing, man. They hit this stuff real good, man. They hit it real good. Right here. Let me see. I think this is it right here. Is the jurisdiction of the Tennessee court sufficiently shown, or having acted, will it be presumed that court had jurisdiction of the person of the defendant? A general proposition, we know that the Circuit Court of Shelby County, Tennessee, is a court of general common law jurisdiction. And if the judgment sued on in this case had been on original process issued from the Circuit Court of Shelby County, Tennessee, the question would be free from difficulty. But the judgment here sued on shows on the face that the Circuit Court of Shelby County, Tennessee, was not undertaking to exercise its general jurisdiction. On the contrary, it shows that the court was undertaking to exercise special appellate jurisdiction conferred by statute. The statutes of the state of Tennessee relating to the question were introduced in evidence, showing the conferring of appellate jurisdiction and appeals from justice of the peace courts, and the manner in which these appeals must be taken in order to give the circuit court jurisdiction. At common law, the circuit court would have no such jurisdiction. Our Supreme Court held that in a case where the jurisdiction was dependent upon statutory enactment, the circuit court is created quo ad hoc as a court of limited jurisdiction, and on appeal, the record should affirmatively show a strict compliance with the creative statute as to all orders enforcing the rights conferred by the statute. It has been repeatedly decided here that, in the absence of a substantial compliance with the statutory provisions regulating and defining the grounds of jurisdiction, the proceedings in the probate court are quorum non judice and are void. All of them are quorum non judice, to be honest with you, because they don't have any judicial authority. As he adds, the existence of jurisdiction is not inferred from an attempt to exercise jurisdiction. The jurisdictional facts must affirmatively appear, but this only applies to courts of general limited jurisdiction. Nothing is presumed in favor of the record. I'm trying to see what they're going to talk about a little equity in here too. I think. Let me see if I can find it. I think this is it right here. Yeah, this was a case originating in a chancery court in Martin versus Martin, Alabama, in a divorce decree. So in a divorce case originating in the chancery court, and therefore a court of general jurisdiction, held that according to the power to grant divorce, a vindicate not of the general jurisdiction of courts of equity, but they are in that respect of limited special jurisdiction, where a special authority in derogation of the common law, they're telling you it's not common law jurisdiction, where a special authority in derogation of the common law is conferred by statute on a court of general jurisdiction, it becomes quo ad hoc an inferior or a limited court. This applies everywhere. The reason for this is because I just told you the Constitution is law. The people created the law. So they created courts to adjudicate their private rights. So these courts that they created to adjudicate their private rights are called courts of general jurisdiction. They hear all cases. They can act with statutes or without statutes under the authority of the Constitution. So you can invoke their original jurisdiction citing the Constitution. You can invoke their appellate jurisdiction citing the Constitution or case law, something like that. That's how you do it. The common law is still here. They don't lie to you and tell you it ain't, but it's still here. If it wasn't, then you don't have a government. If it wasn't here, because the government was created under the common law. The territorial government wasn't, but it's dependent on the common law.
So if you can pull up real quick because it said Jefferson County, not Texas, but they get tricky with their language. You know what I mean?
I'm telling you right now, if they following any statutory procedures, you're dealing with a territorial government. A county is an administrative agency. A county, a city, they're administrative agencies. And they are municipal corporations.
Okay.
Both of them have charters. A county has a charter and a city has a charter. They got it from the legislature. You're dealing with a territorial government. All legislation is territorial. All legislation is comprised of statutes and codes. All legislation does not apply. Statutes do not apply outside of their corporate territorial jurisdiction. They're not laws. Even if the legislature did not create any courts, the system is still complete. I'm not joking, it is still complete. Because the courts of general jurisdiction can adjudicate all of that stuff.
Yeah. So let me look it up because they they playing a little word game right
Yeah,
here.
they do. They slick too, boy. They real
'Cause,
slick.
yeah, because I'm gonna go file a bill in equity tomorrow.
Okay. Do you know how to
Tomorrow,
draft it?
Tuesday. I know I have a template. I don't know how to draft it like you do though. You be drafting them good.
Man, it's easy, man. It's easy. So it sort of works like this. You just plead facts to show that they are contrary to the principles of equity. Any principle
Yeah,
of
look.
huh?
I I want to send you. I want to send you. I want to send you these videos that I have uh from a guy that all these equity guys learn from. You know the guy named Rourke. Uh, I think his name Eric Rourke or something like that.
To be honest with you, I don't think I've heard of that name before.
Let's see if you know new guy on Instagram. His name was he Amir. You know Amir?
No, I don't even be on Instagram, man. I didn't know they had people like this on
Uh,
Instagram. I thought they were just full of stupid motherfuckers.
no, this equity movement is taking over, bro.
That's where it's at, man. Equity is it's
You
always
know
been
Don
political.
Cologne?
Huh?
You know Don Cologne?
Nope.
Man, I have to get your number, man.
I
I
guess
gotta
I'll
get
look
your
at
number.
it.
I'm talking about you got Henry Gibson book?
Yep. I got Story too. I got
Okay.
Joseph Story and
Uh,
Henry Gibson.
I don't know him.
He he
I
was
don't know him.
he was a very young jurist. I think he made it to the Supreme. I think he was like in his 30s or something like that when he first made it to the bench or something like that. But he was an intelligent guy based off my cursory research of him or my brief research of him. He was an intelligent young lawyer, so to speak. But I got both of them though. But that's how I learned it. This man, when you study the principle, that's all you really need for real. You just need to know the principles.
That's it. That's it. Well,
That's all you need.
I'm into beating the child support and stuff like that. I didn't beat child support, uh but now I'm into all the real estate and
Mm-hmm.
perfecting titles and trust law and
Yeah, well, you're gonna need to
stuff
know
like
equity
that.
then. Yeah, yeah. That's what I mean. Equity is applicable everywhere, but especially during private relationships.
Yeah. So what I did to the landlord, I served a trust on him. I served a trust on him last week. So I can already give him notice. And what I'm gonna do is go tomorrow. I'm gonna see if their title is not perfected, and I'm gonna perfect their title. I'm gonna go to the court of general jurisdiction, and I'm gonna convey it into the trust
Uh-huh.
and file a lawsuit, file a complaint,
All right, now if you go
file a
into a
bill,
court of huh,
file a bill.
file a bill in equity. Okay. If you're gonna go to a court of
Yeah,
general
yeah.
jurisdiction, don't use no statutes.
Oh no. No, only
The reason why you
maximum.
don't use statutes is because they already have the jurisdiction to act because they're a court of general jurisdiction. Their authority comes from the Constitution. That's where their authority comes from. The administrative agency's authorities come from statutes.
Yeah, yeah, man. So that's what I'm gonna do. I'm gonna email you. I'm gonna email you, and we can we can have more discussions about it if you want to. And I might just book a consultation with you later on if you free. When you free?
Oh, I had to go and check my schedule, man. I thought I put it in here. Yeah, I did. It's at the top of this video. There's a link to the private consultation. You can just book it whenever you want, and we can just go from there.
Okay.
When is your pay your rent to the credit scheduled to when? I was reading something else. I'm sorry. Go ahead. I'm sorry.
Yeah. I'm gonna get with I'm gonna get a consultation with you. And we can, you know, network and stuff like that.
Okay, that's cool. That's cool. Like did me explaining this stuff to you in regards to general jurisdiction and limited jurisdiction, did that help you?
That helped me out a lot, man.
Okay. They're
They helped me
true,
out a
man.
lot
They're
because
true.
the other guys was like, go to the federal court. I'm like, federal court? I don't even think federal court really part of our government like that.
No, they not.
You know what I mean?
They not. It's you're
You
dealing
know,
with
that-
you're dealing with a territorial government. Like that's
yeah.
you like man, look, as soon as you let's like you say you in Texas, right? As soon as you step off, as soon as you step off on some street in Texas onto to the property of that federal courthouse, you not in Texas no more, fam. You in the United States.
Damn, for real?
Yeah, you in the United States. You go and do something to somebody in that building and watch what happens. The feds coming at you, fam. Ain't nobody from the state coming to get you.
Damn.
That's just like when you go to the post office. You go to you drive down the street, you go to the
90
post
seconds.
office, and you as soon as you step off that street onto the property of that post office, you in the United States. You do something to somebody in that post office and watch what happens. The feds coming to get your ass.
That's crazy, man. These people get to operate. Damn, you're gonna have to do a live on that, man.
Man,
The federal government
60
and how
they
the
just
hell do they get power?
they get this through the state, through the they have to talk to the local state, not the local well, yeah, probably the local and the state government to come out and build, buy not either buy property or lease property or annex property or something like that. But like everybody, like people don't understand, you can do the same thing. You and the government, generally speaking, we on equal footing, except all of our rights are on. I can't even get the words out, but all of our rights are essentially on private property. All of their privileges or rights, or so to speak, are essentially on public property. Generally speaking, you can do the same. For example,
Damn.
you can stop the
10
government.
seconds.
Let me see. How much my time we at? We good. Let's say I've given this example once. I'm gonna give it again. You can let's say I don't care if it's federal property or state property. Let's say you're in a federal building. It's an old building. You know what I'm saying? You find that it's abandoned. They ain't doing nothing to the building. So you discover this building or whatever. It's abandoned. You start fixing this building up to run your business out of. See what I'm saying? And the federal government, they find out that that's what you're doing. But they don't stop you. They don't invoke their right to stop you. And now you've invested all of this money in it. You got the business going and yada, yada, yada. And they come in and they try to make you leave. They can't do that. They step on their rights. You can
Yeah.
they collaterally are stopped from doing that. You can't do that. And I know that
Yeah.
if you study equity, it will clearly tell you that. You can't sleep on your rights.
Yeah. You gotta act.
Yeah, you got it. Like
You gotta act on it.
yeah, that's what's going on. Like that's essentially what's going on. You have the same, but see, they don't want people to know this stuff, man. They don't want people to know this stuff. But I'm telling you right, I done found the cases that'll just blow your mind.
Yeah, man, that shit crazy.
Yeah.
Shit, man, I'm gonna get to work and shit, man. I'll email you.
Okay. All right. Well, I got the link up here to the to the private consultation. It's at the top of this video, and it'll be pinned to this video. So you'll see it. You just go on and watch it or whatever. I mean, click on it. And you can just book
Okay.
whenever you want, and we can just go from there, man.
All right. Cool.
All right, man. Peace. All right. All right, y'all. Sorry about that, y'all. Guess mute up until you're about to talk your background. I'm not really. I don't know what y'all. I don't know what the issue is with the volume. I'm sorry. I don't know what it is. I think got a little off track. I wanted to finish reading this case. I didn't even know. I bet I was on here 2 hours. I didn't even know it. 2 hours just flew by. I mean, I got 2 pages left. I'm gonna read these 2 pages, y'all, and I'm gonna get on off here. Get off here. So this would be, in my opinion, this would be the judge, the chancellor, so to speak. This seems like this is hold on, what did they say? This was an action of, okay, so they said this was an action of a sub, so it's not clearly. This seems to be some sort of bill in equity right here, because they're talking about express contracts, implied contracts, and they're going into the actions of the son and the father in this case. So I'm gonna read this and then I'm gonna get on up out of here. Let me go back and check to make sure y'all can hear me before I go. Appreciate it, man. I appreciate it. Let me just go and do this now, cause I've been to forgot. So YouTube. Also, y'all can go to my YouTube channel up here. Where is it at? Like right here, and click this. It'll take you straight to the how you can book your consultation right here. But I'm gonna copy and paste it for y'all in the chat. I appreciate it, man. I try to make this stuff affordable, man, for people. Well, like if I give people a ridiculously high price or something like that, it's really because I don't want the case. I really be trying to be honest with y'all, I really be trying to force people to learn this stuff on their own, because I cannot do this by myself. I'm just gonna keep it real, which I can't. It's a lot, and then it's your responsibility to know your rights anyway. But let's get to it. The circumstances of the plaintiff's claim are so favorable in an equitable point of view, and the grounds of defense as they appear in the report of the trial so rigid and illiberal that if we regret, let me see, that if regret was to be indulged in the performance of the duty, we should certainly feel no small portion of it on the present occasion. We have indeed looked diligently for principles and authorities upon which the plaintiff's case might be sustained, but without success. There being no express promise, the question is whether the facts prove raised an implied promise against the defendant. Give me a second, y'all. All right, y'all. Sorry about that. Let me get back to the point where they're talking about. There being no expressed promise, the question is whether the facts proved raised an implied promise against the defendant. The defendant in this case would be the father, if I'm not mistaken. The defendant's son had fallen into distress in a foreign country, to which he had fled to avoid the consequences of a crime committed in his native country. He was a minor and without property. The plaintiff, knowing his father to be a reputable merchant, credit, we're talking about credit here, his reputation, a reputable merchant, paid his board and supplied him with such things as were necessary for his condition. In other words, he furnished his son necessaries, relying upon the honor and gratitude of the father to reimburse him, to indemnify his son. The liability of the father must depend altogether upon the principles of law which govern the relation of parent and child. The father is the father is obliged to support his children while they remain part of his family. Perhaps if he failed to furnish them with clothing and food necessary to support, necessary to the support of life, anyone who furnishes such necessaries may maintain an action against the father upon the presumption of an assent on his part, of his consent upon his part. Perhaps also, if he cruelly and causelessly turn them out of the doors, they would carry with them a credit on the father for the means of support. Is this making sense for y'all? I'm gonna go back to this book, what I'm talking about. If he, where's that book at? Right here. The obligation of the parent to support and educate the child is contingent upon the parent actually retaining custody of the child. The Georgia Supreme Court in Thompson again speaks on the natural law of a parent's support of a child in stating that the right to the services of the child and the obligation to maintain them go together. Whatever deprives the parent of the right to the custody and services of the child without fault without fault of the father relieves the father from the duty to support the child. So let's get back to this case, because this is what it's saying without saying it. Perhaps if the father cruelly or causelessly, in other words, at fault, he's at fault if he does this. He's at fault. Turn them out of the doors, they would carry with them a credit on the father for the means of support. Is this clicking for y'all? Is this making sense for y'all? This case is from 1819. This case, what was that, footnote 13? This case is from 1927. I told y'all they been knew about this stuff, man. Let me go and check this chat right quick. All right, let's get back to it. Where we at? Right here. I'm gonna read that one more time. Perhaps also, if he, the father, cruelly and causelessly, meaning without cause, without any justification, turn his kids out of the doors, they would carry with them a credit on the father for the means of support. Although it may be questioned whether in such a case the support of the children should not be provided for pursuant to the statute, requiring the kindred of poor persons within certain degrees to support them. So they talk about some sort of statute in here too. I'm not really sure. But upon these points, the case before us does not require an opinion. However this may be, we think it clear that when a child leaves his parents' house voluntarily for the purposes of seeking his fortune into the world, or to avoid the discipline and restraint so necessary for the due regulation of families, he carries with him no credit, and the parent is under no obligation to pay for his support. Why is that, y'all? Why? The reason for that is because whatever deprives the father of the right to the custody and services of the child without fault of the father relieves the father from the duty to support the child. This is the same exact thing, y'all. It's the same thing. Let's see. Let me go back. It's the same thing. But anyway, let's get back to it. Where we go. This case is still stronger against such a claim when the child has arrived at years of discretion, but not of manhood, shall have violated the laws and become a fugitive from justice. For necessaries, a minor, under such circumstances, in countries where the common law prevails, and probably in all civilized countries, is personally liable. And when his personal liability begins, it should seem that the liability of his parents would cease. An infant, when at home under the care of his father and support by him, is not liable even for necessaries. If he were, I want y'all to pay attention to this. If he were, the father would be deprived of the right of exercising his discretion as to the manner and degree of his support. That is a fundamental right, right there. In other words, you have a right to determine and the manner uh, uh, and the manner in which you render support for your kids. How much money is necessary, so on and so forth, like that. You have a right to do that. That's a fundamental right. But when you go to court and they tell you you got to pay this amount, they're taking that right. They're taking that right away from you. So in other words, they're infringing upon that right. You already have this right independent of a statute. I wonder, are y'all hearing me? Is the volume good? Can everybody hear me? Let's get back. I'm gonna come back and check. Okay, right here. It would seem a just inference from the principles of the decisions referred to that when the authority of the parent is abjured without any necessity occasioned by the parent, all obligation to provide for him has ceased, and that those who chose to supply him do do it at their do it at their peril of the child's ability or the parent's willingness to indemnify them. There is undoubtedly some cases in which the application of this doctrine may appear harsh, but in attention to the consequences of a different doctrine will be sufficient vindication of the principle. Could a refractory or vicious son leave his father's house without being exposed to want, carrying with him a credit on his father wherever he might wander? The motive for submitting to authority might be materially impaired, and a great diminution of parental influence might ensue. One of the greatest restraints upon the bad passions and vicious propensities would be removed if young persons should feel that they could flee their if they could flee their parents' presence without suffering in any of the essentials of life. Without suffering in any of the essentials of life. The law, therefore, has wisely left individual cases of generous inferences to depend upon the honor of those connected with the object of it, rather than place in the hands of thoughtless or ill-disposed youth, their parents' purse to supply their wants with, whenever they should incline to deny his authority and withdraw themselves from his government. In the argument for the plaintiff, we see many reasons to regret that he has been obliged to resort to a suit for money, which he had a right to expect would have, would have been returned to him with gratitude for his well-intended advances. But the law cannot be bent to his case, and we are persuaded that public policy and a due regard to parental authority will sufficiently justify the law. There's another footnote in here too. I think it was 8. Okay, yeah, that's what they're talking about. Let me get back to this. All right, y'all. I'm already been on too long, so I'm gonna go ahead and get off here and call it a night. I'm tired anyway. I'm gonna go ahead and get off here. I try to do another one next Sunday, y'all. I'm tired right now. 2 hours. We'll try to do it again. There's a link, to book a consultation, so we can just go from there. Before I go, do anybody have any questions? Anybody? Any questions? All right. If there's somebody on the line and you want to talk, just press one. I'll answer your question before I leave. We can talk a little bit before I leave. But if not, I'm gonna go ahead and get on off here, y'all. Excuse me. All right. Let me see. Let's turn this back on. We'll turn the screen share off. All right, y'all. Well, look, I'm about to go ahead and log off. Everybody enjoy your Sunday evening. I'll be back hopefully next Sunday. Hold on. So you got a quick question. Okay, go ahead with your question, is you. I was just about to log off. Go ahead. Oh, let me see. The amount above bare sustenance is at the father's discretion. The mere name of a profession is not enough to satisfy the obligation, but an occupation in the lower ranks of life is sufficient. The obligation is not limited to any age, but ceases with forced famulation unless the child shall fall into indigence and want. Well, didn't I have right here? It can wait till next time. All right. All right. Well, I'm going to go ahead and get on off here, man. Good night, everybody. Peace. How do I log off this thing?